Hi, this is Attorney Mike Grevlin coming to you from Chicago as usual. And today I've just got a little update. An astute commenter sent me a little bit from Sovereign Citizen Traffic Stop number 21. I'll put links in the description below. So anyway, this woman who is I guess the girlfriend or at least the student of Devonte King gets pulled over in a traffic stop and arrested. I'm going to play a little bit of that, and then I'm going to show you what happens with her civil filing in federal court. Okay, so like I said, this is an update on a previous video. I'm going to play you just a little bit for those who never saw it, and a little refresher for those who actually did see the video.
Oh, shit.
Reason I pulled you over is the plates come back not on file. Do you have your license on you, ma'am?
Why would I need my license? I'm exercising my constitutional rights. My rights that are protected by the Constitution to travel freely.
Oh boy, here we go.
You have to have a driver's license.
In my private property. This is my private property sign.
Well, in order to drive a vehicle, you have to have a driver's license.
I'm not driving a vehicle, ma'am. I'm traveling in my private property.
Okay, and then here's another little bit towards the end so you can kind of see what happens. Based on the caption, I think that this officer is the one that she sues, but I just wanted to give a little setup and context to the discussion we're going to have.
Because you guys are violating my constitutional rights.
We're not.
But you are, because I have the right to be safe and secure in my person's papers, property, and effects.
Okay. I need you to open the door. I'm asking you to come back to the vehicle. Supreme Court decided that we have the right to do so for our safety. So open the door. We'll open it.
I'll give you my name. I'm not going to open my door, though.
I'm asking that you open the door.
Why would you need me to open my door? For traveling.
Back to the
I don't. I need you to open your door so I can arrest you for driving.
car with us.
Why would I come back to... Am I under arrest?
You're being detained. That's what a traffic stop is.
A traffic stops mean I'm being detained.
Okay, are you going to cooperate or do I have to break you?
I'll give you my name, yes.
I'm asking you out of the vehicle now.
Okay.
Open the door. Okay. Turn and face the vehicle, please. Turn and face the vehicle, please.
This is harassment. Why am I being under arrest? Why?
Okay, so there you have it. That's sort of I believe, the incident that gave rise to this cause of action. So it appears she files in federal court along with Devonte saying there's something wrong with this arrest. And a commenter sent it along to me, and I just thought it was too good to not share. All right, so here we have the case. It's called Reed v. Hovey, and it's it looks like this opinion is dated 3/12/21. So that's only a few months ago as I recorded this video. It's pretty interesting. And here's the opinion. First of all, we see that the plaintiff is Kayla Patrice Reed and Devonte Michael Deshaun King. So that's who the plaintiff is, and it says versus Gary Hovey. I'm guessing that is the guy in the second clip, but it says Gary Hovey et al. So they could add a lot of stuff. I don't have the full caption here, but it's just an interesting thing to go through. This is what I tell everybody happens for these cases, but since I happen to have it right here and somebody sent it to me, I'll go through it with you. It says, this matter is before the court on defendant's motion to dismiss pursuant to Federal Rule of Civil Procedure 12b-6. Okay, so the defendant in the case, which is going to be, among others, Gary Hovey and probably the police department and all that, just filed a motion to dismiss in response. And people always want an update on the court. This is all the court there is. There are probably no court hearings or anything. They probably got the filing, referred it to their counsel. Counsel immediately drafted a motion to dismiss because the pleadings were silly. and then the court issued this opinion. I don't know if there were interim court dates, but that is the way I suspect it probably went. So they go on and on about the standard of review. Motion for summary judgment is pretty, or motion to dismiss is pretty high. You have to assume all facts most favorable to the non-moving party. Okay, so the plaintiff's claim arises out of a traffic stop on the night of December 4th, 2020. The gist of Plaintiff Kayla Reed's complaint is that she was driving home from work when defendant police officers Matthew Prohl and Gary Hovey initiated the traffic stop and threatened to break her car window to arrest her if she did not exit the vehicle. Okay, this may actually be different. Those facts seem slightly different. It does not mention a female officer, or what I suspect is a female officer. Nonetheless, I'm sure it was the same sort of behavior and the same sort of thing. Reed alleges that she had broken no law and the defendant seized her property, presumably her vehicle and its contents, for ransom. The vehicle was apparently impounded and towed. An invoice from the city of North Platte is attached to the complaint, reflecting towing, impound, and tax charges totaling $114.20. Wow, is that inexpensive? That shocks me. All right, based on these allegations, the plaintiff asserts claims under 42 U.S.C. 1983. That is, if you had a legitimate complaint against the police, that's what you would bring it under. She doesn't, but that's what you would do. All right, this part is really rich. I like that. It says, Reed also asserts that the pictures attached to the plaintiff's response demonstrate that there was no way on earth that Mr. Hovey and Mr. Prohl or the North Platte Police Department can mistake my automobile as a commercial motor vehicle. Completely irrelevant, but that's what she puts in the pleadings. All right, so then we get to the nuts of it with the court doing that under discussion. It says, it is clear from the plaintiff's own evidence that Reed's vehicle wasn't displaying Nebraska license plates, and in fact is, under the law, largely dispositive of the case. A traffic stop is reasonable under the Fourth Amendment if it's supported by either probable cause or an articulable reasonable suspicion a traffic violation has occurred. An unregistered motor vehicle may be driven for 30 days without displaying license plates or in transit tags if the vehicle was purchased from an unlicensed seller, but the driver must produce documentation on demand. The fictitious license plates clearly visible on Reed's vehicle provided a reasonable suspicion for a traffic stop. I love that part. The fictitious license plates is exactly what they are. It goes to the core of this whole argument the entire time. And this is just kind of refreshing to see. Here's what happens when they actually bring this in front of a federal judge and try to lay out these horrible arguments that they continue to make on the street, but have no merit whatsoever. Okay, here the court really gets to the nub of the issue. It says the only thing the plaintiff has to contradict any of those facts, and I skip a little bit, is Reed's conclusory assertions that she has broken no law and done no wrong. See filing 11 at 9. Considering the record as a whole, it's clear that Reed's statements to that effect are more representative of an esoteric understanding of what the law requires than genuine factual disputes. But even if construed as statements of fact, they don't help. The question is whether officers' belief that unlawful activity was afoot objectively reasonable, not whether it was actually correct. I really like this bit. In response to their 14th Amendment argument, it says, the quote says, this might seem obvious, but the constitutional right to travel isn't implicated here either. First and foremost, because travel between one state and another isn't at issue. In the absence of a constitutional violation for Hovey or Prohl, there's no basis for North Platte to be liable either, as the city acted entirely through them. But for the sake of completeness, the court notes the absence of any allegations or evidence suggesting that the city had a policy or custom that resulted in constitutional violations. Finally, the court notes that the complaint suggests certain theories that might be state law tort claims, such as trespass. To the extent that the pleadings present any state law claims, the court declines to exercise supplemental jurisdiction over them. The defendant's motion to dismiss, treated as a motion for summary judgment, is granted. The plaintiff's complaint is dismissed. A separate judgment will be entered. And, all that means is they filed a suit against these police officers in the city of North Platte, and the defendant filed a motion to dismiss. Since additional evidence was brought in, the court viewed it as a motion for summary judgment and granted it. In either circumstance, what it means is the case is dismissed and the plaintiff's lost. Well, there you have it. That's what happens when the sovereign citizens file their civil suits under 1983 in federal court. They get dismissed. I say that all the time, and I sort of dismiss it. I thought I would, because it was right before me, I thought I would go through and explain it, just so you could see if you're really into the inside baseball of this stuff. I even filtered out a lot of that stuff. I can do that real quick. They do the standard of review for a motion to dismiss, and that took a while, but it's pretty high. But their complaint was really bad. They did a long section on qualified immunity, saying you didn't state a cause of action, but if you did state a cause of action, these people would be immune from it. I'll just summarize that. And the last thing is they treat it as a motion for summary judgment because the plaintiffs don't know what they're doing, and they filed a bunch of additional material outside of the pleadings to answer the motion to dismiss. And on a motion to dismiss, you're supposed to say within the four corners of the pleadings. The court said, instead of getting fussy about that, what we'll do is we'll take all of that into account and say you still lose, but since we're taking that into account, we're going to call it a motion for summary judgment. So the plaintiff sort of transmuted the defendant's motion to dismiss by their response, but that's okay. This is just all the ins and outs of what happens, but the short version is they don't have a meritorious claim and they got thrown out at the first opportunity, just as we knew it would.
Here at Law Talk, we answer all your legal questions and give detailed analysis of current events. Who am I kidding? We just mostly laugh at horrible court appearances. And occasionally you might learn something, but I promise I'll try to keep that to a minimum. Thanks for watching.